If you run a care home, a supported living service, or a domiciliary agency, you'll find this video helpful because the law on deprivation of liberty has just changed. On the 2nd of June 2026, the Supreme Court overturned a judgment that's shaped how we do DoLS for more than 10 years. And already, I'm hearing providers say, "Brilliant, does this mean we can stop doing DoLS?" No, it does not. Because if you get this wrong, it isn't paperwork you're risking, it's someone's rights. And your CQC rating. Welcome back to CQC Queen Academy. Today, what this Supreme Court judgment actually means, and the 5 things you should be checking in your service this week. So let's start with what's actually happened. For over a decade, we've all worked off something called the Cheshire West Acid Test, which asks 3 simple questions. Does the person lack capacity? Are they under continuous supervision and control? And are they not free to leave? If the answer was yes to all 3 questions, we treated it as a deprivation of liberty and we put a DoLS in place. Then, on the 2nd of June, in a case brought by the Attorney General for Northern Ireland, some people are calling it Cheshire West 2. The Supreme Court said that acid test was wrong in principle. It was too crude. It swept up hundreds of thousands of people who didn't need to be swept up. So the acid test is gone. In its place is something called a multifactorial assessment, a fancy phrase that just means you have to look at the whole picture. The type of restriction, how long it lasts, the effect on the person, and, crucially, what that person actually wants. But here's where providers can trip up. The court said a person's wishes and feelings now carry weight. So if someone seems settled, content, not objecting, that might mean it's no longer a deprivation of liberty. Notice I said might, because this is not a free pass. Not objecting is not the same as agreeing. A person with dementia might not complain because they're confused. A person with a learning disability might smile because they want to please you. A person who's autistic might follow the routine because change feels overwhelming, not because they've freely chosen any of it. In fact, the judges built in a safeguard for exactly this. They called it the serious doubt rule. And it's simple. If you're in any doubt about whether the person genuinely consents, you assume they don't. So the question was never just, are they quiet? The question is, what do we actually know about this person's wishes, feelings, safety, and rights? Let me make this real. Meet Mary. Mary's 84. She lives in a care home, she has dementia, and she can't safely go out alone because she gets lost. The front door has a keypad. Staff check on her regularly. She seems settled. She enjoys her meals. She chats with staff. She never asks to leave. Now, a provider might look at that and go, Mary's happy. No problem here. Maybe. But that's not enough, because when CQC or the local authority or a safeguarding team asks you about Mary, she seems fine is not an answer. It's an observation. It is not evidence. You still have to ask, has Mary's capacity been assessed properly for this decision? Does she understand where she lives and why? Has anyone spoken to her family or her representative? Does she ever get distressed at certain times of day? Does she try the door at night? Is the keypad the least restrictive option? Because when CQC or the local authority or a safeguarding team asks you about Mary, she seems fine is not an answer. It's an observation. It is not evidence. So here's the biggest mistake I think providers might make. Assuming the bar has disappeared. It hasn't. The bar may have moved. But your responsibility hasn't gone anywhere. You still need person-centered care. You still need consent where you can get it. You still need capacity assessments, best interest decisions, and restrictions that are necessary, proportionate, and reviewed. And here's the part nobody's saying out loud. Where there is still a deprivation of liberty, DoLS still applies. The judgment didn't switch it off, and there's no grace period. It applies from day one. So if your reaction to all this is, great, less paperwork, be very, very careful, because the real issue was never the paperwork. The real issue is whether the person is safe, respected, listened to, and lawfully supported. The paperwork is just how you prove it. Let's take a harder example. Meet David. David's 25. He has a learning disability and he lives in supported living. He says he likes it there. He likes the staff. He doesn't want to move. But staff tell him when he can go out. He can't get his own money without staff. His phone is monitored, and he's discouraged from seeing one particular friend because staff think that friend is risky. This is where you slow right down, because you cannot just say, David's happy, so there's no restriction. There clearly are restrictions. Some might be necessary, some might be genuinely good safeguarding, but every single one needs to be thought through. What's the risk? Who decided this? Was David involved? Was an advocate involved? Is there a less restrictive option? When's it being reviewed? That, right there, is the line between professional care and controlling care. And the uncomfortable truth is, sometimes providers don't even realize they've crossed it. Now let's talk CQC, because they've already put out a statement on this. CQC isn't just interested in whether you can quote the law, they want to see how your service protects people in real life. So, when an inspector opens a person's file, they're looking for evidence. Not a beautiful policy that nobody uses, real evidence. A capacity assessment that's decision-specific. A best interest decision where one's needed. A care plan that explains the restrictions clearly. Proof that the person's wishes and feelings were genuinely considered. And please, stop writing for safety reasons and thinking that explains everything. What safety reason? What's the actual risk? How likely is it? What have you already tried? If it's not written down clearly, it looks like you're making decisions for convenience. And CQC will not like that one bit. Let's bring this back to the actual person. Because deprivation of liberty sounds like a legal phrase, but it's about someone's everyday life. Can I go outside? Can I choose where I live? Can I see my friend? Can I decide when I go to bed? Can I take a risk, like every other adult is allowed to? Sometimes we get so focused on safety that we forget freedom, but safety without freedom becomes control, and freedom without support becomes neglect. The whole job, the hard job, is balancing the two. So, practically, what do you do this week? First, don't panic. Second, don't assume nothing's changed. And third, do not start ripping up your DoLS processes without proper local guidance. Interim guidance is still being published. Then run the people you support through 5 questions. 1. Do we know whether this person has capacity for this specific decision? 2. Do we know what they actually want? 3. Are we restricting them in any way? 4. Can we explain why that restriction is necessary and proportionate? 5. Is there a less restrictive way to keep them safe? And if your honest answer to any of those is, I'm not sure, that's your action point. Not sure means review it. Not sure does not mean ignore it. So here's the bottom line. Yes, the Supreme Court has changed how some of these cases will be understood, but it has not removed your responsibility to think carefully, record clearly, and protect people's rights. So please don't use this update as an excuse to do less. Use it as a reason to do better. Because when CQC asks you, how do you protect people's rights? Good intentions won't cut it. You need evidence. And the person in your care, they deserve more than a tick box. They deserve to be safe, listened to, and as free as they possibly can be. If this helped, subscribe to CQC Queen Academy, plain English guidance on registration, compliance, governance, and inspection readiness. I'll see you in the next one.